1804, the City of Taylor versus Zachary Page.
And good afternoon, Your Honor. For the record, Matthew Zick for the people.
Okay, and I have a note on here. The people are requesting the case be set for a jury trial, and the defendant wants to fire the MIDC attorney. Is that accurate? Mr. Page, are you asking to represent yourself?
Yes, Your Honor. I'm representing myself.
Okay. Okay, you have a right to represent yourself, but I want to make sure you understand this, Mr. Page. You have a right to do that, okay? But you understand that attorneys go to law school and they study the rules of evidence. And if a person who is not a lawyer wants to proceed in a case, they're held to the same standard. You have to play within the same rules as a lawyer when you represent yourself. Do you understand that?
Yes, ma'am.
Okay, Mr. Page, I want you to see this. This is the Michigan court rules. This book is the rules that govern how we do trials, how evidence is admitted, how questions are asked, how trials proceed. And I'm going to assume you've not studied that book. Do you understand that if you go to trial and you represent yourself, that you will be held to the same standard and will be required to comply with those rules?
I understand.
Okay, is there anything else you want to put on record?
Yes.
All right, go ahead.
I, Zachary Page, lowercase a-h-a-r-y, P-A-G-E, a living man and one of the people of the Constitutional Republic of Michigan, appearing today sui juris. I'm here under special appearance and...
Before we even step foot into this courtroom, let me warn you, what you're about to see is not a legal defense, it's a performance. Today's video gives us a front row seat to one of the most predictable yet fascinating spectacles in the justice system, the sovereign citizen playbook being read, literally. In our first case, we're heading to Judge Shackelford's courtroom, where a defendant doesn't just believe the script, he's visibly reading it off camera, word for word, hoping that Latin phrases and constitutional buzzwords can confidence, same inevitable collision with reality. What makes these cases so compelling isn't just the legal failure, it's the psychology. The misplaced confidence. The misunderstanding of basic legal concepts. And the moment where the judge makes it painfully clear that belief does not equal immunity. So buckle up, because today's breakdown isn't just about what happens in court, it's about why these arguments keep failing, and why some people
Under these trust agreements, public officials act as trustees and are bound by their oaths of office to serve the people, the beneficiaries. Their primary duty is to uphold and protect the inherent and unalienable rights of the people, as mandated by these constitutions.
Okay, all right, Mr. Page.
I have more.
I know, you can submit it in writing. I've heard it all before, sir. If you want to be a sovereign citizen today, that's fine with me. All right, but we're going to get through this court proceeding, and I want you to know you're going to behave at trial. You are bound by the laws of the state of Michigan, and that's how we'll be proceeding. So, sir, as to arraignment, how do you plead? You can plead guilty, you can plead not guilty, or you can stand mute.
Could you repeat the last part, please?
You could stand mute. That means you don't say anything and I enter a not guilty plea for you. So a guilty, not guilty, or...
This is one of the most important moments in the entire hearing, and it's where most sovereign citizens mentally check out. Judge Shackelford isn't being dramatic, she's laying down a fundamental rule of the courtroom: if you choose to represent yourself, you don't get special treatment. You don't get leniency because you did your own research. You understand the law better than attorneys, yet this warning alone should terrify anyone who actually grasps how complex evidentiary rules are. Objections, foundation, relevance, hearsay, none of that disappears just because you don't recognize the court's authority. This is the judge giving him a very polite off-ramp before things get ugly. And judging by what comes next, he doesn't take it.
Police authority. There is an allegation that on November 4th of 2024, while traveling southbound Telegraph near Brest Street in the city of Taylor, that you engaged in behavior that obstructed or interfered with police authority. That is the allegation against you. This is a misdemeanor. It is punishable maximum by up to 90 days in jail and a fine of up to $500. Sir, you have the right under the Constitution to have a trial by a jury and to have the assistance of an attorney. And you have a right to an attorney appointed at public expense if you are indigent, meaning you don't have the money to pay for an attorney. And if the offense requires a minimum jail sentence, there is no minimum jail sentence on this case, or the court determines it might sentence you to jail. It's my understanding that you have waived your right to a court-appointed attorney. You've already put that on record, and you intend on representing yourself. You also have a right to a trial. And at that trial, you have the following rights: to call witnesses to speak for you at trial, and you can get an order signed by the court to require witnesses to come to court. You have a right to see, hear, and question all witnesses against you at trial, to be a witness for yourself or to remain silent. And if you chose not to be a witness on your own behalf, the prosecuting official may not comment on your refusal to testify. You also have a right to be presumed innocent unless proven guilty beyond a reasonable doubt. Those are your rights under the United States and Michigan Constitution. Do you understand what I just read to you, sir?
Yeah.
I'm not asking if you agree, I'm asking if you understand. And is that a yes?
And here we go, the moment every sovereign citizen case eventually reaches. The lowercase name, the living man, the constitutional republic, and the claim of appearing under a special status. This isn't spontaneous. This isn't original. This is a memorized script pulled straight from online forums and jailhouse lore. And the biggest tell? He's reading it. What makes this especially telling is that he doesn't even fully understand the terminology he's using. These phrases are designed to sound authoritative, but legally, they mean absolutely nothing in this courtroom. Courts recognize people, not fictional legal personas or trusts allegedly created by the Constitution. And judges have heard this exact speech hundreds of times. That's why the confidence collapses the moment the judge cuts him off, because once the script ends, there's no backup plan.
You'd like to be referred to as American National Valentine?
Present.
Okay. And is that how you'd like me to refer to you?
Yes, ma'am.
Okay. I don't remember that. So, sir, there was a warrant issued for your arrest back December 6th. You had posted bond on the previous warrant. We had a hearing, and that's what we're here about, is we're still pending trial. And you weren't, the pretrial services violation, that's right. We've got a positive UA from November 1st for THC and cocaine, November 20th, a dilute one, but concerned about THC and cocaine, November 22nd, a UA positive for cocaine. So that's why we're here today.
Cocaine is a hell of a drug.
And I remember in the past that you were representing yourself. Is that still your intention?
Yes.
Okay. So let me turn to the status to this warrant issue, and then I'll turn back to you. And Mr. Weston?
Your Honor, this time the state would be asking that the current bail be increased to $10,000. It was previously, the state previously asked that amount at arraignment. The court previously imposed $15,000. That somewhere throughout the process, the court decreased the bail to $5,000. He posted the bond for that amount, and which I believe he was released on October 29th, and within a month we have all these pretrial violations. And so the state has substantial concerns about him not following the release conditions that he's required to follow, especially being on pretrial release for DUI. And so the state's asking that the court impose $10,000 bail at this time and that he either posted or turned himself in.
So, Mr. Valentine?
So I object the state motion. The release conditions that were set were not returned. Ooh,
I can hear you. I can.
okay. Yeah, the release conditions that were set were not returned to its original state. The release condition only changed because the 3 charges were added. And once the 3 charges were dismissed, our release conditions were supposed to be returned to personal recognizance. There was other individuals when I was in custody that were in the same situation. The state brought charges against them, but the state didn't have the physical evidence yet, and they released those individuals on their personal.
Right here is the reality check sovereign citizens never prepare for. Judge Shackelford doesn't argue with him. She doesn't debate constitutional theory. She doesn't engage the fantasy. She does something far more effective, she ignores it. Because legally speaking, these arguments aren't wrong, they're irrelevant. Courts don't exist to entertain ideological protests. They exist to adjudicate charges. And when the judge tells him, if you want to be a sovereign citizen today, that's fine with me, what she's really saying is, your beliefs don't change jurisdiction, procedure, or consequences. The trial is moving forward whether he accepts it or not. This calm dismissal is actually devastating to these arguments, because they only work if someone plays along.
Based on my knowledge, Your Honor, there's no blood draw in this case. The state is ready to proceed. It was American National Valentine that did request the continuance of trial confirmation on 11/8.
So you've got everything. You're
Yeah,
not
we got
waiting for
everything.
intox reports. Okay. All right. So back to you, Mr. Valentine. Anything else? Or I'm sorry, American
Yes.
National Valentine.
The state was awaiting the toxicology report for case number 4A0027328. Those 3 charges that were added on to the case was the reason why I was in on the ankle monitor and working with friendship services. And so since those charges were dropped, I'm only on the case for my DUI, my first DUI. I never had any previous DUIs. This is my first DUI. I was only brought into custody for the extra charges that were added on, and those charges were dismissed. But the release conditions were never changed.
So
Even my
this
bail,
one-
they didn't even lower the bail. I had to argue with the court just to get the bail lowered, even though the charges were dismissed.
So this one is alleged from November 13th of 2021. And then I see that there was a January 1st of 2024 that was dismissed. And now it looks like that has been refiled with an arraignment date scheduled for January 14th. Don't know if you've gotten that in the mail yet
Yes,
or
I
not.
have.
Okay,
Yes, I have.
so, all right, so you're right. These conditions are only about the case alleged from November 13th of 2021. Gotcha. All right. And that's the court order on that matter. 1A730693 was the pretrial services requirement and the requirement of sobriety. All right. So you're saying that, and tell me if I'm wrong, you're saying that I should release you, set this on for trial, and what about conditions of release?
So the conditions to release, I should be back PR'd as I originally was with this charge. If on the other case, like how you said,
This exchange exposes one of the biggest contradictions in sovereign citizen ideology. On one hand, they claim the court has no authority over them. On the other hand, they still rely on the court to respect procedural rights like pleas, jury trials, and presumptions of innocence. You can't have it both ways. Standing mute isn't some magical loophole, it's simply a procedural safeguard to keep the case moving. And notice how quickly confusion sets in when the judge calmly explains it. The mythology online makes this sound like a power move, but in reality, it changes nothing. The case proceeds, the plea is entered, and the legal machine keeps rolling. This is where belief crashes into process, and process always wins.
To October 28th to change the release conditions, and that was denied. I guess that was me. From the court's docket, that's what I'm reading. And so that was considered already, and that was denied. So, and now I have these allegations from pretrial services. So, all right, Mr. Valentine, we've had difficulty with getting compliance while you're on release. We've had difficulty with getting into court. And so I am going to increase that bail amount to, because 5,000 apparently isn't working. And I don't know what else to do. Pretrial services supervision isn't working. And so at this stage, a 10,000 cash or bond bail needs to be posted. You're appearing on Zoom. So either post that 10,000 cash or bond bail by Friday at 3, or you're in custody by Friday at 3. So you make that decision. And then we'll have a hearing I'm gonna set this it's going to set everything for that January 14 day. And so that we've got everything together. What time that is, but you either, as I said, 10,000 cash or bond bail to be posted no later than 3 o'clock on Friday the 20th, or you're in custody by Friday the 20th at 3, no later than 3. But we'll set this hearing. The next hearing will be January 14th at 2:30. It's a pretrial.
This is the moment the consequences become real. Up until now, this has felt theatrical, speeches, terminology, posturing. But once the judge lays out the charge, the date, the location, and the potential jail time, the fantasy cracks. Interference with police authority is a real charge, with real penalties, and none of it is neutralized by constitutional buzzwords. What's important here is how methodical the judge is. She's building a clean record. She's ensuring the defendant understands his rights. And she's eliminating any future claim that he didn't know what was happening. Judges do this not to help the prosecution, but to protect